Hi, this video is a really quick overview of the effect of intimate partner violence on family law. I've given you some further readings if you're interested in this topic. In 2006, the Family Law Act was reformed, allegedly to focus on changing the culture of family breakdown from litigation to cooperation. The critique of this approach is that in many situations the family culture has in fact utterly broken down due to family violence, often from one partner to another, and one partner is often left as a result of that in a situation where cooperating with their violent ex-partner is actually dangerous. This leads to a range of outcomes in family law, which has been somewhat overlooked, despite the Family Court's intention and the Family Law Act's intention to actually take it into account. A team of researchers, including our own Zoe Rathis, has done some recent work on family violence, family reporting, and parenting orders. For those of you who haven't studied family law, when a parent seeks an order in relation to their children, we call them parenting orders. The two most common types are orders to decide where the child lives and who the child will have contact with. Often as part of the process of getting parenting orders, a family will be directed to meet with a family report writer. A family report writer may come from a range of different backgrounds, including psychology, social work, etc. These people will observe the children, and then the children with each parent, and often the children with both parents. The research that Rathis and others have done has actually found that for many family report writers, they do not have a good grasp of the effect of family violence on the interactions between children and their parents. And in fact, often assume that reports of family violence are made up to affect the family law process, or that they've been exaggerated in some way. Even where the person who reports family violence is believed, that is often then treated as an individualized rather than a systemic social effect. So it's often seen as a dispute between two people rather than that one partner is using a pattern which is seen over and over again in society to gain power over the other partner. It's seen more like having an individual and equal fight. They also often downplay the effects and severity of family violence in their reports. So why is this a problem? Well, in the family court, children cannot give evidence. This is done to protect the children, and personally I think it's probably a great idea. It stops kids being put in the middle with parents pressuring them to give evidence for one or the other parent. So the person who speaks for the child is often the family report writer. And if the family report writer is someone who believes that domestic violence is an individualized dispute problem and who downplays the effect of the violence on both the spouses and the children of violent people, then that leads to some bad outcomes in relation to parenting orders, and it can lead to longer term problems for the kids. In addition to there being issues around family report writing, there's also been a series of studies that show that generally women who have experienced violence in the home get worse outcomes in their family law settlements, and that can be both their parenting settlements and their property settlements. In our current processes for family law, it is required that parties attend a conciliation process before they file court documents in parenting matters. There are some limited provisions for people to not have to do this where there has been serious violence, but it is still often goes ahead with less serious violence, and in times where there was a history of abuse which did not involve physical violence. And this means that people who have been abused by their spouse have to go into a small room and negotiate often with staff, for example, at Relationships Australia, as mediators or conciliators, and then try to come to a settlement before they can go further and actually seek a court process. This process usually occurs without lawyers present. And in these situations, studies have found that generally people who have experienced family violence do worse than those who go through the process without a history of family violence. They say that the reasons for this are probably due to ongoing dominance and control issues, in that there is a history and a pattern of behaviour that leads to habitual capitulation to a dominant partner, and a willingness to exert power by that dominant partner, that practitioners may not always have a great deal of experience or awareness of family violence effects, or they can be subtle enough that the practitioner doesn't realise them, or the practitioner is trying very hard, as they must, to be fair to both parties, which may lead to an overcompensation in not assisting a person who is a victim of family violence. In theory, under the Family Law Act, contributions, when you're looking at dividing property, you look at the contributions and needs of the parties, as well as the history of the property of the family, the property that's available to them, their future needs, etc. There have been findings in cases that say that where a person has been a survivor of family violence and the other party has been the perpetrator of family violence, that should actually increase the amount that the survivor of the family violence or the victim of the family violence should get in their settlement, because it makes their contributions harder. They're doing it in the face of violence every time they do something to contribute to the family or to the family property. However, this doesn't often play out in negotiated settlements or in settlements leading up to court, or even sometimes in the court process, particularly where a judge finds, based on a family report writer, that a person is an exaggerator or a liar in relation to family violence, because then they're often seen as a liar in relation to the accumulation of property or parenting patterns. This means that many survivors of family violence receive less property than they should in theory out of their the family property divisions. It's very common for survivors of family violence, and particularly female survivors of family violence, to have a very substantial effect on their financial status when they leave a violent partner, and that it takes substantially longer for them to recover their financial status after a settlement compared to their former abuser. And as I said, this can be partially a result of the favouring of privatised family dispute resolution, which allows for extremely private and individualised outcomes rather than a court overseeing outcomes to ensure fairness where there's been a history of family violence. So if you're interested in this topic, there is more information in the readings. Please go and have a look at it.